So you're an Illinois landlord and your tenant just stopped paying rent. What do? One option is an eviction, but the problem is navigating the eviction process. In Illinois, it can seem like traversing a complex maze with legal jargon, strict deadlines, procedural nuances. In some cases, it might even feel as if the tenant has more rights than the landlords do. This video will show you how the eviction process in Illinois works, so you know what your options are. However, one caveat. In Cook County and in Chicago, they have special landlord-tenant ordinances with some different requirements. So what I'm saying here today does not necessarily apply to an eviction in Cook County or in the city of Chicago. I'm Scott Richmond, and I'm a real estate attorney with the law firm of Ariano Hardy Ritt. And since 1981, we've been helping Chicagoland landlords with their tenant problems. And when it comes to tenant and landlord relationships, we've seen it all. One of the most common landlord issues that occurs is when a tenant stops paying rent and you're forced to explore eviction. The first step is recognizing what constitutes grounds for eviction. In Illinois, common reasons are the failure to pay rent, a violation of the terms of the lease, for example, having pets where they're not allowed, damaging property beyond normal wear and tear, or engaging in illegal activities on the premises. When there's been a violation, before any legal action can be commenced in the court, the landlord has to provide the tenant with written notice. The duration of this notice varies depending on the type of eviction. First of all, where there's non-payment of rent, typically a 5-day notice to pay is required. If there's a lease violation, like I said before about having illegal pets, for example, typically the landlord must give the tenant 10 days to remedy that violation. And if they do, they get to stay, but if they don't, the landlord can initiate eviction. And finally, if the landlord determines that they don't want to renew the lease because the lease has ended or it's a month-to-month lease, the landlord has to provide a 30-day notice to the tenant, and that 30 days begins on the month following when the notice is given. It is crucial that these notices are delivered correctly. Improper delivery of the landlord's notice to the tenant can result in delays or even dismissal of the eviction lawsuit. Now, I tell all my landlord clients that posting the notice on the door or sliding it under the door or leaving it in a mailbox is not proper service. I always recommend personally serving the tenant or serving somebody over the age of 13 who lives in the residence. Once the proper notice has been given, if the tenant fails to correct the problems, the landlord has a right to file an eviction lawsuit. An eviction lawsuit is filed at the local courthouse in the county where the property is located. Tenants are then served with a summons and a complaint. And then that document gives them a date in court. At the initial court date, the tenants are sometimes given an opportunity to file an appearance and try and resolve the case, typically about 28 days. At the end of that time, if the parties don't have an agreement, the matter will be set for trial. Documentation is key here. The landlord has to have the lease agreement, and that has to be attached to the complaint. The landlord has to have records of payment. The landlord has to have copies of the eviction notice and proof that it was served on the tenant. All of these are necessary to substantiate the claim. Once there's a trial in court, the judge is going to make one of two decisions. The judge may find in favor of the landlord and will enter a judgment of eviction, which means that by a certain date set by the court, that tenant has to leave the premises and take all their belongings with. The judge may also enter a judgment for the money that's owed to the landlord in the form of rent. Now, if the tenant wins, the court will enter a judgment in favor of the tenant, and the tenant will not be evicted. But it's important to note that even after you get a judgment as a landlord against the tenant and the judge sets a date where the tenant has to be out, that only gives authorization for the eviction. It is only the sheriff's deputies that are authorized to physically remove the tenant and their property from the landlord's residence. The landlord cannot engage in what's called self-help, meaning the landlord cannot change the locks, cannot remove the tenant's belongings, or do anything else to interfere with that tenant's right to possession until the sheriff comes to do the eviction. There's a couple things to note once the tenant is gone and has been evicted. Oftentimes, the tenants have to find alternative accommodations, which could necessitate seeking assistance from local community organizations, especially if they're facing homelessness. Landlords also may need to repair rental units, preparing them for the next occupants, potentially involving repair costs that may exceed the security deposit that the landlord has. It's important that once the tenant leaves, the landlord should go in, inspect the property, take pictures, take videos, and then prepare proper documentation of all the costs for repairing the premises beyond normal wear and tear. If things are just dirty, that's normal wear and tear. But if there's big holes in the wall and things like that, the tenant may be liable for paying for those damages. Now, it's never easy considering all the emotional, financial tolls involved at both ends of the spectrum when an eviction is involved. But it's essential that everything is done according to the law, or it can and will cost you a lot more in the long run. It's also important as a landlord to understand that the eviction process can take up to 3 to 4 months to complete. And therefore, it's important as a landlord not to wait when a tenant fails to pay rent. Being the nice guy and waiting to start the eviction process can wind up costing the landlord much more given the length of time it takes to complete the eviction process. Schedule a time to meet with our trial team to review the eviction process and get all your options. There's no cost to meet with us, and we will tell you all of your options.